Council. Today is Thursday, October 14th, and the first case we are going to hear is Janice, Eddy, and Samantha Bray versus the Big Show Limited. It's case number 21CA011715. As you can see, your panel this morning is Judge Callahan, who will be keeping time for us today. Thank you, Judge Callahan. And Judge Hensel and myself, Judge Teodosio. Each party will have 15 minutes to present their arguments. And of course, appellant may reserve up to 5 minutes for rebuttal. If you're going to do that, please let Judge Callahan know and she'll keep track of that time for you and let you know as you approach the rebuttal time. The judges on the panel have read the briefs and we are prepared to proceed if you are.
Good morning, judges. Giovanna Bremke on behalf of the Big Show. I would reserve 5 minutes of my time for rebuttal. And I believe it'll probably be a quick argument this morning. The facts are not complex of this case, so feel free to ask me questions. This case is about a catering contract in the middle of the global pandemic. Miss Eddy is the plaintiff, is the mother of Samantha Bray. Samantha's wedding was to take place at my client's catering location, and then the pandemic hit, and the wedding, I believe, was to take place April 20th of 2020, and because of the pandemic, the plaintiffs or appellees canceled the wedding. There are 3 assignments of error. The first being that the sole reason that the court basically rescinded the contract and entered a judgment against my clients were based on receipts. These receipts were never entered into evidence. And so neither party actually requested that they were entered into evidence, and there was no dispute about payments. Page 2 of the entry of the decision notes that it makes notes about these receipts. Even if they were admitted and the note mentions this, these were email confirmations. It's important to note that it's a small claims case, and neither of the parties or even the court at the time had brought up about the Ohio Sales Consumer Practices Act. So that was not a position that was pled in the small claims complaint, nor was it brought up at the small claims hearing. The first time that this was mentioned was in the decision. And the court, again, rescinded the contract based on the provision of the Ohio Administrative Code 109-4307, which is part of the Ohio Sales Consumer Practices Act. And it has specific wording as to what receipts need to be. But again, these receipts were never admitted into evidence. And it's important because my clients had didn't have an opportunity to present a valid defense because of the fact that these were originally never admitted into evidence. Second
assignment. Were they testified to? Excuse me. Were the receipts testified to at trial?
Yeah, again, it's a small claims case, so it's a slightly different, but yes, there was I would say more of discussion regarding the payments, and there wasn't a dispute as to the amount of payments. There was, at one point there was talk about these receipts, and I would say email confirmations. But the significance of that is an email confirmation is not necessarily a receipt, and this OAC language, had my client been prepared, had the court or the plaintiffs in the matter brought up this argument, my client could have been prepared to present those receipts into evidence. because no receipts were admitted into evidence, and that was pretty much the only thing that the court relied on, that, you know, that's an issue. And this again falls under the manifest weight of the evidence. There's also an issue that the contract states that the payments were not refundable, even for cancellations, and they did cancel their wedding because of the pandemic. The second issue is the fact that the court used an equitable relief, which is not permitted under revised code 1952.02, to rescind the contract, and that's not permitted. An equitable relief is not permitted in a small claims action. So if you look at the last page, page 5 of the entry, the trial court explicitly says that the plaintiffs are entitled to rescission of the contract and for full return of the full amount of which was a little over $5,000. The significance of this is that again, it's not permitted. It was never. There's two things that the appellees sort of bring up. One is that it was not objected to. Again, rescission was not. It was not an issue at the court level. It was not pled. So it wasn't something that until this decision came that my clients could have been prepared to argue. So this court relies on a case that's similar in its Berlin versus Alex Continental Inn. And that's the main case that the court relies on. And that case started as a small claims court, but was transferred to the general division. And I believe in that case, the contract was rescinded. The difference there is that it was transferred to the general division. This case was not. So under small claims court, yeah.
Sure, but couldn't this case be looked at as a breach of contract claim? And the court certainly has jurisdiction for breach of contract claims. And maybe for want of a better explanation, the court was holding that they were entitled to the refund on a breach of contract basis.
Well, I think the argument that you're bringing up is sort of the second argument that the appellees raise, is that although it says rescission of the contract, what the court meant was that they should get this money back under maybe another claim. But my argument is it's explicit. It says that they were entitled, the plaintiffs are entitled to rescission of the contract. That's not an equitable relief. It's clear it's not permitted in small claims court under the revised code. So while the court could have potentially, I'm not conceding that, but the court could have looked at it as a breach of contract and maybe potentially, you know, decided on a different issue. That's not what the court did. The court rescinded the contract. And I believe that, you know, it's not just harmless error, because under a different claim, it could have been a different amount, even if the judge was going to enter a judgment, it could have been, again, under a different amount. This was the entire amount because it was a rescission. And lastly, the third assignment of error is a short assignment of error, just that the court in this matter shifted the burden of the questioning to the big show attorney. The pro se plaintiffs in the matter did not do the questioning, and he relied on the attorney and the big show's attorney to do that work, in effect shifting the burden. So I would reserve the rest of my time.
All right, thank you. Attorney Millett.
Yes, good morning. Thank you very much, Court and Attorney Bremke. One thing that's important in this case to remember is this was a small claims court case. Miss Eddy and her daughter appeared pro se. And the civil rules do not apply in small claims courts. So the fact that the court decided to get the facts from both sides simultaneously, there's no error there whatsoever. I'm addressing your last argument there. So as far as shifting the burden, that makes no sense to me. The court made no finding that the burden was going to be shifted to the defendant. The court clearly agreed to transfer. The court clearly placed a burden on the plaintiffs and determined that the plaintiffs have met that burden. Of course, the appellee also argues that the manifest weight of the evidence did not support the decision. I think that's clearly incorrect. The trial court had this case before them for upwards of about an hour and 45 minutes, and took a substantial amount of evidence and had a chance to review the credibility of the witnesses. One of the things counsel said that I totally disagree with is the fact that the plaintiffs tried to cancel this event. No such cancellation ever occurred. In fact, there was email exchange in which the big show tried to basically determine, are you canceling? Are you canceling? And Ms. Eddy said in an email, court read the decision on April 9th, 2020. Ms. Eddy replied, I have no intention of canceling. I paid for the services contracted in a timely manner, and I want you to fulfill your half of the contract. It's important to know that Ms. Eddy's contract required she make 5 payments, which she made faithfully. The last payment took place, a substantial amount of money, $1,300, after the governor's order was issued. So she was, to her own peril, decided to go ahead and try to pursue the contract and put them in a position where so the big show in a position where they had to perform. Now, granted, they could not perform. At the time that these payments were made, no one knew how long this might last. Miss Eddy tried to rightfully reschedule after the lockdown was lifted, and she was told by the big show, well, that's another $600, which she's not rescheduling on her own volition. She's rescheduling because the governor required that to occur. So she essentially said, I'm not paying another $600. I'd like to have my money back, please. We don't know how long this might last. And that's where she ran into the roadblock with the big show. And that's why this complaint was filed. As far as pleadings in the small claims court complaint, again, there's no pleading requirement here. This is a pro se case. Mrs. Eddy, I think, clearly said what the issues were in her complaint. There's no problem with that. And finally, I want to mention this receipt issue, which has come up. So the court found that the first receipt, if you will, was the contract. And the contract contains the cancellation requirements buried in the fine print. But after that, there were subsequent payments that were due. Every time Mrs. Eddy made a payment, there was an email exchange. So those email exchanges are, in fact, a written document that can act as a receipt. And they did not meet the requirements set forth in the Administrative Code section 109 that the court cited. I think the court's interpretation of that code section was quite reasonable. It wasn't arbitrary. And so I don't think the argument also holds any weight. That's essentially my argument. I also wanted to, and I guess at the risk of sounding too aggressive here, I did make a motion that this court find that this appeal was not warranted. There's no reasonable basis for this appeal, and that sanctions should be issued. This is a woman who was in a small claims court by herself, and then the judgment was issued. There was really no legal problems whatsoever with that judgment. I know of no case that says that there's an impossibility of performance that the contractor gets to keep the money. The other argument that was made is that the relief here was not appropriate. I think my brief sets out that there is an exception in the small claims court statute that allows for this type of action to occur under 1345. The court found that there was an unfair business practice here, and that's why they ordered that sanction. Essentially, none of the arguments made by the appellant carry any weight whatsoever. Thank you.
What about the argument that the court rescinded this contract, and that's beyond the relief that can be granted by a small claim court?
I set that out, Your Honor, in my brief. If you look at 134502, it says that the trial court may order the relief if for any violation 1925-02, excuse me, Your Honor. The court may award any relief for a violation of 130502, 03, or 031. The court did find that 130502, which prohibits deceptive trade practices, was violated by Administrative Code Section 1094, and clearly the statute has the exception in there to allow a rescission or at least the money be refunded. I wouldn't even call it a rescission. I would just call it a equitable refund based upon the circumstances, the fact that the contract cannot be performed. What else could the court have done here? Besides what they did, and I think they had authority under the statute to do that.
Well, you said
the big should perform, Your Honor.
the court made an equitable decision.
It's not
Excuse me,
equitable.
but you just said the court.
My argument. I'm sorry, interrupt.
All right, I thought you just said equitable relief.
Well, it's not equitable relief. It's a money judgment. Essentially, it's a money judgment. There's no equitable relief here. It's getting your money back from a business that can't perform because of the COVID shutdown. If you want to, the court used the word rescission. The plaintiffs never pled that or never asked for that. That was the court's own language. And I believe that what the court did was proper under 134502. Under 1925-02, because there's an exception in there that allows the court to grant relief in a consumer case. It's 19.
Any other questions for?
I'm sorry.
I'm sorry. Are you done with your argument?
I have to say it's 1925-02, section A2B has that exception in there. Yes. I'm sorry.
All right. Any questions for counsel, Judge Callahan or Judge Hensel? No. All right. Thank you, sir. And Attorney Bremke, you have
Thank you, Your Honor.
your rebuttal time.
Yes, Your
Bremke,
Honor.
you have your full 5 minutes.
Thank you. I'd just like to address the issue again of the rescission. The appellees make the argument that this was essentially a refund. That's not at all what the court says. The court speaks through its entry, and the entry says rescission. So that's not it's clear, there's case law I cited. It's not permitted for rescission of a contract for equitable relief in a small claims action. There is, and I think they probably made the argument, what else could the court have done? Again, that's on the, first of all, it's on the plaintiff. If the only thing is equitable relief, then small claims wouldn't have been the appropriate venue. And second, there are other, I would submit to the court that we already spoke about this, that there are other potential relief that the court could have provided absent a rescission, even if the court wasn't going to rule in my client's favor. Again, I do think that I think to say that there's no, that there's no successful argument, I think that that's incorrect. And almost say that argument is frivolous, because there's plenty of law that cites that that rescission is permitted or is not permitted. I'm sorry. There's plenty of law that talks about admitting these things into evidence, not pleading, all of that nature. There's certainly arguments to be made here. We would ask that you reverse the judgment. Thank you.
1925-02 does permit the court to grant relief for deceptive sales practices acts and violations of the Consumer Sales Practices Act, though, doesn't it?
Your Honor, I would say that the case law that I pointed out does not permit that. It's not permitted. What the plaintiff should have done is they could have asked for this case to be transferred to the general division, just like the case that cited did. I would argue it's not permitted. Thank you.
All right, that's how you interpret that particular section of the code?
Yes, Your Honor.
I mean, all right. Anything further, Attorney Bremke?
No,
Let me see if there's any questions. Judge Callahan, any questions? No? How about Judge Hensel? Any questions? All right, thank you. Well, thank you both for your arguments. The court will take the matter under advisement. We'll issue a decision in due course. Of course, each of you will get a copy of the decision when we issue it. And as you know, the court's decisions are posted on the Supreme Court's website. Thank you again, both for your arguments, and have a good day.